Good afternoon, the City of Ibadan. Reaching out to you is Justice Chambers, Faculty of Law, Lead City University, and I remain your humble host, Igwilo Mary Ann Adora. Welcome back to Legal Affairs. Now, this is a show where you get to know about your legal rights, your legal duties, your obligations, where we bring awareness to you, and the platform where you make calls, where you air your opinions, your views, and your grievances. Now, today we have a very special guest in our midst. A very special guest. We have our learned father. We have our very much prominent lecturer in the Faculty of Law, Lead City University, a mentor to so many, in the person of Dr Olu Ojedoku.
Yes, top of the day to you. Thank you for inviting me.
So today we have a very interesting topic to discuss and to bring to your awareness. Today we'll be talking about judicial review. So, firstly, we already know that basically we have three arms of government. We have the judiciary, we have the legislature, and we have the executive arm of government. The executive, which is responsible for enforcing the laws, the legislature responsible for making the laws, and the judiciary responsible for interpreting the laws. Now, we have several mechanisms to ensure that within these arms of government there are checks and balances and all that. Now, one of the major mechanisms is judicial review. That is the power of the judiciary to be able to look into the decisions or review the decisions of other arms of government to ensure that it's not against the provisions of the Constitution. So now we'll be bringing into the show our special guest to ask him some questions and to throw more light on the topic of judicial review. So, sir, we would like you to throw more light on the concept of judicial review and its practical application in Nigeria.
Well, you've given it a very good background. Lord Atkin said, power tends to corrupt, and absolute power corrupts absolutely. In other words, judicial review is a form of judicial control. The other controls, of course, we are not discussing today, legislative control and executive control. But judicial review is part of judicial control. In other words, how you sort of control or review, rather, delegated legislations. The court scrutinizes them. And delegated legislations, of course, legislation which are delegated to the executive. So in other words, it's the actions of the executive that are being reviewed, that are being scrutinized. And there are a number of prerequisites for that to be able to happen. The rule first is that you must have had recourse to administrative remedies where they are available. There's the doctrine of rightness which applies, the doctrine of ultra vires, local standing, which is very important, and we will speak a lot of that. There's the right of appeal, possession of jurisdiction. But I think the important thing about judicial review is not about the rightness of the action that has been taken by the executive, but it is rather whether the correct procedure has been followed, whether the executive body has acted within its power. All those sort of things are the things which matter. So it is possible, for instance, you go to a university, for instance, called University of Aberdeen, the vice chancellor is appointed, and somebody raises the question, not that the vice chancellor should be appointed, but that the means, manner, and the procedure adopted to appoint the vice chancellor, you understand, is ultra vires, which means that the body that appointed the vice chancellor don't have the power to do that. And so the university concerned will be asked to go back, look at the procedure, and do it correctly.
All right. Thank you very much, sir. Thank you, sir. Because we all know that there are three major principles of judicial review, and the first has to do with the Constitution being the supreme law of the country. The second has to do with the Supreme Court having the ultimate authority in ruling judicial constitutional matters, and the third having to do with the judiciary has the right to upturn a decision when it's not in compliance with the provisions of the Constitution. So I want to ask, to what extent does the Constitution itself have influence in this matter of judicial review in Nigeria?
Yes, it of course has influence. I mean, unfortunately for us, judicial review is not used that often. People would rather pursue other remedies, but it's important. We must remember the locus classicus case of Senator Abraham Adesanya versus the President of Nigeria. That's a case that happened around the 1980s.
Okay.
And in that case, the president had proceeded to appoint Justice Obiebwiski as the president, or the chairman rather, of the electoral body. It was called FEDECO then. Through the National Assembly, they had scrutinized and confirmed the appointment. Of course, Adesanya had objected. He was a senator, serving senator, and then he took the matter to court, for the court to review the decision. And the problem with Adesanya was that the court came up with a novel, not novel, it's an old principle, locus standi. In other words, it is not enough for you to have a right course of action. It is not enough for you to be guaranteed by the Constitution. But you must have locus standi. You must have the legal right to sue.
Yes.
You must have the competence to sue. You must have interest, which is over and above, those of others to sue. It's not enough for you to say I have an interest. We're not talking about romantic interest. We're not talking about fraternal interest. We're talking about legal interest. And that's key to judicial review. Without that, this court cannot assume jurisdiction from that point of view. So in Nigeria, a lot of times, if you look at the case of Director of SSS versus Abakoba, it was more or less the same issue. In that case, the Supreme Court affirmed the judgment of the Court of Appeal and made an order for the defendant, respondent, the state security operatives to release the applicant's passport to him because they had no power to pound it in those circumstances. In other words, the act went beyond the powers delegated to them from the enabling statute which established the state security service. So of course the Constitution is important because it establishes parameters which you should not go beyond. But even if you want to exercise those rights, you must have locus standi. In other words, you can't just say University of Aberdeen, the College of Medicine there has been proscribed, and you happen to be a busybody citizen in Lee City University and say, oh well, I love University of Aberdeen, therefore I'm going to go to court on their behalf. No, it wouldn't do. You don't have sufficient interest. You don't have locus standi.
Thank you very much, sir. That was a wonderful answer. Okay, sir, I want to ask, looking from the viewpoint of justice, what would happen to a country that no judicial review exists? In a situation where judicial review does not exist in a country, the judiciary does not have the right to look into and upturn decisions and all. What happens to that country?
Well, in the military era, we've had some of that happen, where some of the jurisdiction of the courts was ousted. It goes back to the principle of law acting. I said it before, power tends to corrupt. And absolute power corrupts absolutely. So what will happen will be a corruption of power. It will mean tyranny. It will mean despotism. It will mean that citizens will be living under the fear of a dictatorship. Because judicial review allows the judiciary to go behind, to go into the secret decision-making mechanism of any government and to see whether or not they follow the right procedure. Even if during the era of decrease, military era, before they ousted some of the jurisdiction, the court reserved the role. Many a times, you have the case of Lacomi versus AG of the West. You understand? They went behind to see whether the federal government, military government, and indeed the state government followed the right procedure. Of course, we know that the decree later came out to overturn whatever decisions they had, but at least they were able to go to see whether it was done correctly. Many a times, when a detention order has been issued, through this whole process of judicial review, they've been able to examine it. And there was a case of Tai Sholari versus State Security Service. It wasn't the detention order said it must be signed by the Chief of Staff, Supreme Military Headquarters, and it wasn't. It was signed by his assistant. So the court threw it out. Unfortunately for Tai Sholari, just as it was being brought out, they brought a validly signed one, and of course it was thrown back into the gulag. So as I said, if you don't have judicial review, we'll be poorer, and we'll be none the wiser, and of course we'll be living under despotism.
Very true. Thank you so much, sir. All right. So we're going on a very short break, and when we come back, we will give you more insights on judicial review. Thank you. All right. Welcome back to Legal Affairs from Justice Chambers, Faculty of Law, Leeds City University. Before we proceed, you can call our hotlines to air your opinions, your views, and whatever contributions you have. 070-695-66844, 070-695-66844, All right, still on the matter of judicial review, we should know that another name for judicial review can be inquest or appeal, and the judiciary have several times upturned several cases for over more than 100 years. They've upturned several cases and all that, and one of those cases. Okay, we have a call. Hello, good afternoon. Welcome to Legal Affairs. This is what are we speaking to? Hello? Alright, continuing. So we're on the case of Roe and Wade, a case that was being upturned by the decision was being upturned by the Supreme Court. The decision was based on abortion was an unconstitutional act, and then the judiciary upturned the case and all that. Now, the major purpose of judicial review is in order to ensure that there is checks and balances between the three arms of government, in order to ensure that there is no decision that is being taken that is against or inconsistent with the provisions of the Constitution, which is the ground norm of Nigeria. Okay, so we have a question to ask. So pertaining to is there any provision that makes is there any provision that provides for ouster clause of judicial review in Nigeria in the Constitution?
Well, not so much. Well, there are some areas which are non-justiciable, of course. You know, remember the objectives of state directives of state policy. I didn't quote it correctly, but anyway, you get the point I'm making.
Yes.
So there are some areas, education, social justice, and so on and so forth. But generally, even those areas could be subject to judicial inquiry, inquest, or review. For instance, if particularly the legislature has made a law in those areas, so that gives an inroad for the judiciary to get involved. But when we have military regimes, when we've had military regime right from the beginning, from the Imransi to the Yakubu Gowon, to Murtala Obasanjo, to Babangida, to Abacha, and of course to Buhari, the military has always sought to oust the jurisdiction of the judiciary. Why? Why have they sought to limit it in terms of this inquiry? Because decrees and the way they are made, they're very secretive.
Yes.
And usually decree is about trying to enforce, you understand, the supremacy of the military. The military seeks to do what? They have a command and control structure. And judicial review is not about command and control. Judicial review is about how do you control the excesses of the government? How do you control the excesses of the powerful against the poor and against the less privileged, as it were? Yes.
All right, we just received a call. Hello, good afternoon. Hello. Hello, good afternoon. Yeah, good afternoon. You're on to welcome to Legal Affairs. Please, what's your name and where are you calling from?
Hello, I don't know.
Yes, please, what's your name? Welcome to Legal Affairs. What is your name and where are you calling from?
My name is Dr Olu.
Okay. Where are you calling from?
Library.
Okay, all right. Thank you very much, Ogoluwa. So, please, what's your question or contribution to this topic, judicial review?
Huh?
What's your question or contribution to this topic of judicial review? Okay. All right, we lost the call. All right. So thank you so much, sir, on that insightful knowledge on judicial review. So because of time, we'll be moving on to another very brief subtopic, which we will be very much interested in. That is judicial remedies. Now, when we talk about judicial remedies, they can also be called legal remedy or judicial relief. It's actually the right of a court to issue out a court's order. It can be in form of enforcement of right, it can be in form of a penalty to ensure that there is compensation to an injured person. And this judicial remedy usually applies to civil cases in Nigeria. Now, there are several examples of judicial remedies in Nigeria. We have the writ of habeas corpus, we have declaratory judgments, we have injunction, we have damages, we have mandamus, we have certiorari, and so on and so forth. So we'll be issuing out some questions to our guests to throw more light on generally the evaluation of judicial remedies in Nigeria and its practicability. Does it really apply in Nigeria and circumstances?
Yes, of course, it applies. You see, where there is a right. Is that what it says? Where
Yes.
there's a wrong, rather, there's a remedy.
Yes.
Ibu, GC,